All right.
All right, Miss Gray, what would you like to tell me? I'm most interested in whether you wish to have contact with the defendant and if you have concerns for your safety.
Yes, I do. I also have other kids in the home. I have a 23-year-old daughter in the home. I have a 15-year-old son in the home. I have an 8-year-old daughter in the home. Mr. Gray is my oldest child. He drops in and drops out. Okay. I can't have someone come there terrorizing me and my kids in the home that I have built for the last 16 years. My husband and I have built for the last 16 years. Mr. Gray is on some mess trying to live like he's one of those sovereignty people, those people that squatter all the time and just take over people things, because they don't want to get up and get it on their own.
All right, so it's fair to say you don't wish for him to return to that
I
address.
don't wish for him to return to the address. No.
Yes, ma'am.
I
All right.
feel like it would be unsafe. It would be unsafe for me, my husband, and my other three kids.
All right. I do appreciate you coming to court making that statement. Defendant's going to receive $1,500 surety bond. He's to have no contact with Miss Gray or Mr. Robinson during the pendency of this case. He's to stay away from that location, have no alcohol, no drugs, no weapons. His case is going to state all purpose on March the 10th, and I am going to ask that a social worker visit for additional development of the matter. Best of luck to you, Mr. Gray. That concludes your case for today and to all parties concerned.
Today's video looks at three separate cases involving individuals using similar types of arguments in court. In the first case, a mother speaks about a serious incident involving her son, who injured a family member and later caused further harm after being released, which resulted in him being taken back into custody. The second case features a man presenting the familiar claim that he is simply traveling and therefore not subject to certain legal requirements. In the third, another individual faces the risk of losing his home after attempting to avoid paying 2023 property taxes through a discharge of debt, approach that was not accepted. We'll begin with the first, shorter case and focus on the mother's statement to understand how the situation unfolded.
And so for you, Mr. Nope, is it still your intention to move forward with a contested hearing?
I'm sorry, sir. I'm having a very difficult time hearing you. Could you please speak a little louder?
Sure. I was just confirming it's still your intention to move forward with a contested hearing today.
Well, sir, I am being put in a contested hearing box, but if you've noticed all the documents I've set to the court, I'm challenging much more than that, including I'm here by special appearance only. I'm not here by general appearance. I'm challenging jurisdiction. I'm challenging every aspect of this and violations of due process, violations of law, and the fact that I was never notified about this and that it was already turned into a committed without me ever receiving any notification. Have you had a chance to review all of my letters and requests for disclosure and discovery, my affidavits? I've put many documents into this and I'm challenging all aspects. So I can't really even say it's just a contested hearing, other than that's the only box you gave me any possibility to sign on this thing. And by the way, this was only a warning I was given. I was never issued a citation. The citation is not a charge. I mean, the warning is not a charging instrument. It's simply a warning. I've been stopped times before and no citations were issued, and I've been stopped after and no citations were issued. This one suddenly miraculously turned into a citation long after the fact, and it was already termed committed, which is absolutely a violation of my due process. I would also challenge entirely the officer's report and the citation and many other aspects in regard to due process and law. And I can say much more if you will allow me.
All right. Well, Mr. Nope, give me a moment here. I do have all your documents here, and I'm looking at the docket notes for your case as well. So let me take a look at a couple of things here, sir.
Okay, I'm sorry, I couldn't hear that last part.
I said I've got your documents here in front of me, and I'm going to take a look at a few things here before before we move forward, I'm going to get myself more up to speed, but I do have all your documents here. So give me a moment, please.
Okay, thank you.
All right, Mr. No, have you received any documentation from the prosecutor's office in response to your demand for discovery? Looks like that was filed on January 13th.
Well, no response was ever made to all my requests for disclosure and discovery or my affidavits. So I would assume they stand as fact in law. They were not rebutted or they were never answered. Then I did get from the office, not from the prosecutor himself, but from the office, from some woman claiming to write the affidavit, and sent a copy again of the officer's report, which I will contest every element of, and the citation again, as if that is all I'm entitled to in terms of discovery and disclosure, which I do not believe is.
That brings us to the end of the first case. As mentioned before, choosing to follow unconventional beliefs or approaches, especially in situations involving family and legal matters, can sometimes lead to strained relationships and difficult personal consequences. Now, moving on to the next hearing, we look at another individual who was initially stopped for a relatively minor issue, a defective taillight. However, the situation developed further and eventually resulted in a citation for driving without insurance, showing how quickly a simple stop can turn into a more serious legal matter.
So what we're going to do, Mr. Nope, I'm going to put you under oath. All right, I'm going to ask you some questions about what happened, and I'll try to also kind of walk through, how we got here. So please raise your right hand. All right, you swear or affirm the testimony you're about to provide is the truth, the whole truth?
As best I can remember, yes.
All right. So first of all, to address the issue with the earlier finding of committed, it looks like that was found committed due to a failure to respond, which does happen after folks don't respond to a traffic ticket. Part of that notice of infraction that you get does outline ways to respond and some deadlines, and we don't hear a response that becomes a found committed. Now you're here, which means if folks, even after it's found committed, if they engage with the court and set a hearing, then they are able to come back and contest their tickets here. So we are here at a contested hearing despite that earlier finding of committed. All right, now it sounds to me like based on what you've submitted and what you're saying today, you've got two issues here. It's like the stop and then the issue with driving without insurance.
Yes,
right,
this is not a moving violation. This is a paperwork's warning.
Well, I'll let you. I've read the police officer's report as well. I know you've already said made some arguments here, but now you're under oath, so I'll go ahead and let you explain your position with respect to what's in the officer's report. That is what we're focusing on here, is just that October 11th traffic stop and the allegation of driving without insurance. So go ahead.
Okay, so I want to make sure I understand. You're telling me I'm only have the opportunity now to challenge the officer's report right now? Is that what you're asking for?
Well, no, I'm saying that's the officer's report is alleging you were driving without insurance. And if you want me to find that not committed, I would suggest that that's what you focus your arguments on.
Okay. If you look at the officer's report, it is false where he states he was in the very beginning. The officer was down a side street perpendicular to the road coming down out of Rainier. Perpendicular, hiding in the dark on a side street at approximately 12 midnight. I saw the officer car from way ahead. It's a 25-mile-an-hour speed zone at the bottom of a hill, but I was not speeding, nor did he stop me for speeding. Hang on. the officer could not see my brake lights, one brake light that he's claiming was out from that position. Also, I might add, there were two officers, and that's omitted completely from this officer's report. There were two officers, and one tried to give me legal advice. Now, I was not speeding. I saw him. I went down the hill. He was already pulling out after me before he could ever see any brake lights. Then, as I went forward to the stop there, the stop sign in the town of Rainier, that would be the only place he could have seen that. He is misstating completely. First of all, he was not driving, as he said. He was parked down a side road.
I'm going to just butt in here a little bit. So you're not cited for driving without a brake light. I understand that was the reason for the stop. The citation here is for driving without having your insurance.
Right, I'm getting to that.
Right. I would suggest that you get to that a little bit quicker.
Well, these are the circumstances that prove that he's not telling the truth. In my point of view.
It might help to present your argument more clearly, because as it stands, it is difficult to follow and does not align with how the law is applied. Addressing your main point about not being a 14th Amendment citizen, even if that claim were accurate, it would not change the outcome of the case. Legal requirements, such as carrying valid insurance, are not limited to citizens. They apply to anyone operating a vehicle on public roads. Under RCW 43.30.020, drivers on Washington roadways are required to maintain proper insurance coverage. So even if the initial premise were accepted, the conclusion would still not support the argument being made, and the legal obligation would remain in place.
He's not even saying properly where it occurred, because I was stopped out on the highway. He then followed me after I made the turn on Highway 507 toward Yelm, and followed me for a great distance before he made the stop. So his report is false, where he's even saying he stopped me. It was not at the intersection of Binghamton and Idaho streets. That was where he was hiding, down low, where it started from. That's not where he stopped me at all. So that is false. The next thing is he is not telling the truth about the discussion that went down there. And I put him on notice if any of my rights were violated or my due process was violated, that I would take the matter further into court. And that is what I'm doing. So many elements of this are improper. So I asked for this officer's report to be a cause for dismissal, as well as all the other things I've motioned.
Well, Mr. Nope, what you haven't said is you haven't denied that you were driving without insurance. Is that what you're arguing?
Well, the point is are you making me an offer as if I have insurance now, or are you asking me a question about then?
On October 11th, 2025.
I think I have the right to not answer that question under the Fifth Amendment because of all the other issues I've outlined that are improper in this case.
Well, Mr. Nope, you don't have to answer, but the officer said that when he pulled you over, indicated that you didn't have insurance, and driving without insurance is an infraction under state law. And so I do find that infraction has been committed.
Wait a minute. That is not what he said. He said I didn't show him proof in that moment. He then demanded that I email the proof to him, which is not proper or due process at all. It was not that I did not have it or show it. He simply claimed that I did not show him proof at that moment.
Are you saying you showed him proof?
What's that?
Are you telling me that you showed him proof of your insurance?
I handed him a bunch of stuff that I wanted to get out of there because I felt the situation was very dangerous. I don't recall what I actually handed him, but I also gave him the discussion that I'm not in commerce, and I do not believe I am required to carry commercial insurance as that RCW is suggesting, or that it can be proven to apply to me.
Setting tone aside, the core legal point is quite clear. Requirements such as insurance, registration, and licensing are not based on whether someone considers themselves special or outside a certain category. In most jurisdictions, including Washington, these obligations apply because of the act of operating a vehicle on public roads. The law focuses on the activity itself, not personal interpretations of citizenship or status. That is why courts consistently treat these matters as standard regulatory requirements tied directly to road use, and they are enforced regardless of how an individual chooses to define their legal identity.
All right, well, Mr. Nope, I am finding that the infraction committed. The RCW does say failure to provide proof of motor vehicle insurance is a traffic infraction, and you are required to carry motor vehicle insurance while driving on the public road. So I do find that committed. All right, you'll have 60 days to pay that, the ticket amount. And I understand that's not the outcome you're looking for here today, but that's the ruling of the court.
Then, well, I would like to say something more.
Well, Mr. There is an appeal process. All right, we got a lot of folks on the calendar today, and we are going to move on.
I need to ask about appeal. I need to appeal this then.
All right.
So
well,
I need to get the form for informa pauperis to be able to appeal this, because I cannot pay the fine or the filing fees to appeal this. So I will be appealing this, and I need to know what I have to do.
What you got to do is you contact the Thurston County Superior Court Clerk's Office, and they can get you all the information you need for appealing a traffic citation out of district court. That's where the appeal goes.
And how much time do I have to do that?
They'll be able to tell you that process is over in Superior Court. So talk to them and they'll let you know.
It's quite rare to hear someone state so directly that laws do not apply to them, especially in a courtroom setting where legal standards are clearly defined. Statements like that tend to stand out because they go against the basic framework the court operates within. With that said, the arguments have been presented, and the process now moves forward as the judge prepares to deliver a ruling based on the law and the evidence before the court.
Mr. Powell, would you unmute yourself, turn on your camera, and state your name, please?
Powell, Michael Elliott, authorized agent for Michael Elliott Powell.
Ms. Soroka, what property?
Yes, Your Honor, Mayada Soroka with Wayne County Corporation Counsel appearing on behalf of the treasurer, and Mr. Powell's objection to foreclosure of the residential property located at Portlands in Detroit with parcel ID number 210200155 is based on his statement that the taxes have been paid and exempt from levy. However, currently there is a property tax delinquency in the amount of $1,931.34, which consists of tax year 2023. And this is the date and time designated for Mr. Powell to be provided with an opportunity to address the court.
Mr. Powell.
Okay, let me open up the email because she didn't state the entire objection. I've been waiting for about 3 hours, so I didn't know you guys gave me improper notice. I had to call in and get the meeting ID, and I'm currently doing something. So I'm about to pull open this email that I sent them so we could get to the bottom of it. That wasn't the entire objection. The entire objection is, okay, taxes been paid, and what she said, property or security so deposited is exempt from levy. I tendered twice the amount in December. So in December, it was due $1,881.64. I tendered a total of $3,763.28 in security, exclusive of interest, costs, and attorney fees on the liens entered against me on the official tax of Eric R. Sabri. These payments equal to the amounts which I was liable for under the official tax. I presented a verified claim for $1,881.64 to the treasurer. The claim contained the statement of facts stated right now and demanded payment of the $1,881.64 in conformity with the official tax of the treasurer. More than 45 days has elapsed since that presentation and demand of claim during which time Eric R. Sabri has failed to allow or reject the claim. So he's in default for not returning my security to the delinquent tax revolving fund. Everything has been provided to them, and
Your Honor, the fact remains that there is a property tax delinquency for 2023 in the amount of $1,931.34. If this amount is not paid in full, or a payment agreement has not been entered into by March 31st of 2026, the property will be foreclosed.
Okay.
We would recommend that you speak to one of the treasurer's representatives who is here today to enter into a payment agreement or to be provided with payment options.
That's not a response to what I said. So I already tendered payment. It's in your possession, and I have a receipt from Comerica Bank that you deposited my payment in Comerica Bank.
That brings us to the end of the second hearing. Situations like this highlight how challenging things can become when arguments are built on ideas that do not align with how the legal system actually operates. It often leads to outcomes that are frustrating for the person involved and difficult to resolve effectively. With that wrapped up, we now move on to the third case, where a new set of circumstances and arguments begins to unfold.
So you keep saying that your record is incorrect, and I know that. I just said I filed a claim.
Excuse me, sir. Did you attach a copy of the proof that you made the payment?
No, because nobody asked me to.
Well, if you're
the opposite party has not requested any type of proof. So affidavit, unchallenged affidavit is proof. She hasn't challenged any part of what I just said.
Okay,
all she did was go ahead.
At this time, what if you're saying that you made the payment? All we need to do to confirm it so that we can get this off the tax roll is verification. Mr.
Right. And I would like her to go get what's in Comerica Bank and show the court what they put in Comerica Bank, because at this point they lost it.
No. If you made a deposit, that you just have to have your proof. But anyway, Mr.
I sent proof. Go ahead.
Excuse me?
I said I sent proof.
Just hold on, sir.
Your Honor, any payments that would have been made by Mr. Powell would have been applied to any tax delinquency. Usually it is applied to prior tax delinquency years, and then what is remaining is this $1,931.34 for tax year 2023.
Is there
right? And I've spoken with somebody at the Treasury Department multiple times and provided proof. Okay, I sent a claim on the amount
Hold on 1 second.
I sent a claim on the amount I paid. It's been more than 45 days. It has not been rejected. I have not been contacted about, and that's accord and satisfaction.
Your Honor, it seems to me that Mr. Powell is assuming that there is some sort of breach of contract here on the part of the treasurer, but the Wayne County treasurer, in performing his duties, is not classified as a debt collector in the state of Michigan, and is therefore statutorily exempt from the definition of the debt collector under the Fair Debt.
I didn't say the word debt collector.
Hold on. Okay, Mr. Powell, you cannot interrupt, please. Thank you. Go ahead.
But this is not a contract or an accord or satisfaction or any sort of, situation that Mr. Powell is claiming. I think Attorney Don Lee Cotton has looked up the tax payments and would like to address the court.
Ms. Cotton.
Yes, Your Honor. Mr. Powell has been in contact with our office, and we've spoken to him multiple times as to what he sent into Comerica Bank, and I just forwarded to Attorney Soroki what indeed was submitted was just the tax bill where he stamped it, just stating that it was tender.
That's not how the process works. A debt cannot be removed simply by sending a stamped notice claiming it has been discharged. If that were possible, financial obligations would have no real structure, and anyone could avoid payment without consequence. In reality, debts, especially something like a property loan, require proper repayment through legally recognized methods. If someone wants to keep their home, The obligation must be met through actual payment or an approved legal resolution, not by submitting documents that declare the debt settled without any valid basis.
You're wrong. You just said somebody correct me if
I
I'm
was
wrong. Now you
talking
said I
to, I
can't.
was talking to the
You
county.
said somebody. You didn't say county.
Anyway, as I indicated, if it has not been tendered in US currency, not putting a statement on it, that is not sufficient. You must pay the $1,931.34 by March 31st, or else there will be a foreclosure on this property.
I understand what you just said. Now you just said before that equivalent U.S. currency
No,
or
I didn't. No, no, no.
currency.
I'm done.
It's been recorded.
Okay, fine.
It's
I
been
know it
recorded.
has
You
been.
literally said current.
Okay, but the
Okay,
thing
you
you
said
haven't
currency
paid for it.
equivalent, ma'am.
If you
Hold
haven't
on.
paid,
I
I'm
did.
done,
I have proof.
I'm done. I'm done.
Okay,
I'm done. I'm done. And if, as I indicated, if it's not satisfactory funds, if the funds have not been paid, then your property will be foreclosed on March the 31st. You need to make sure you pay that $1,931.34 by March
I'm going to tell
31st.
you again.
You need to pay it by March 31st, or the property will be foreclosed on. No notice, no anything. If it doesn't satisfy, you don't pay those in US currency funds, and equivalent means a credit card, a checking account. That's all that's acceptable. If you do not do that,
So
your property will be foreclosed upon March 31st. At this
I understand
juncture,
everything you're saying.
okay, that's
Now,
all we need.
may I be? Okay, why am I here if I can't be fully heard?
Because you're
I
not,
have the First Amendment right to be fully heard.
you have 2 minutes, sir. 2
Okay,
minutes.
thank you for allowing my First Amendment
Go
right to be
ahead,
fully
2
heard.
minutes.
You- Can I reset it since you interrupted me? So I deposited cash equivalent according to United States law, which is the governing law of all United States currency. Title 31, United States Code, Section 9303 is the code that you're quoting without quoting it. So it says, I may use a government obligation for security instead of a surety bond, which is the same as using cash, check, or money order. I sent a bond, a claim to the treasurer with or secured by the public obligations of the treasurer, which I have the legal right to do, negotiable by delivery, which was deposited into Comerica Bank. I did not send it to Comerica Bank. I sent it to the P.O. box of the treasurer. However, they sent me a receipt signed by Comerica. So where if they sent me a receipt by Comerica, that means the treasurer received my documentation, my documentary evidence, and deposited himself in Comerica Bank. I didn't send anything to Comerica Bank directly. I'm telling you, I have a receipt from Comerica Bank, signed Comerica. However, I sent it to the P.O. box of the treasurer. So the treasurer obviously sent it himself to Comerica Bank. Now, I haven't been rejected. Comerica Bank hasn't called me, has not sent back anything to me, has not rejected anything I sent whatsoever. However, they have accepted for more than 45 days now. Now, the law says clearly, using a government obligation for security instead of a surety bond is the same as using cash checker security. That's what a cash equivalent is. That's what it says in the United States law. Title 31, U.S. Code, Section 9303, if anybody would like to look that up.
Okay, your
Also,
time is up, sir.
Hey, okay, listen, I will file a request for your oath of office and your bond. The other law is Michigan compiled law, the Michigan compiled law 221.87 at sequence, which is the accounts and settlement thereof.